Good afternoon, everyone. My name is Scott Hogreef, and I will be discussing the Commerce Clause. The objectives of my presentation are to define the Commerce Clause, give a history and overview of the Commerce Clause, discuss some laws and challenges pertaining to the Commerce Clause, and illustrate some ethical implications. So first off, the Commerce Clause is enumerated power of the United States Constitution, Article 1, Section 8, Clause 3, and allows Congress to regulate commerce with foreign nations, Indian tribes, and among the several states. The goal of this is to prevent individual states from undermining international treaties and preventing states from forming coalitions and causing undue competition that is harmful to the nation between other states, usually through the passage of tariffs. The part of the Commerce Clause stating that Congress may regulate commerce among the several states is referred to as the Interstate Commerce Clause. So the Interstate Commerce Clause generally goes over and discusses transportation of property between one state and another, persons from one state to another, navigation of public waterways, and the purchase, sale, and exchange of commodities between states. This clause is intentionally left to be vague to allow the clause to be open to interpretation. So I'm going to discuss several acts related to the Commerce Clause that have ethical implications that were either upheld or struck down because of the Commerce Clause. The three acts that I'm going to go over are the Fair Labor Standards Act of 1938, Civil Rights Act of 1964, and the Patient Protection and Affordable Care Act, colloquially named as Obamacare. First, the Fair Labor Standards Act of 1938, it established the 40-hour work week, a national minimum wage, overtime pay, and prohibited most employment of minors. This established a floor for a minimum standard of living for workers. It improved their quality of life, and it started the conversation for a living wage for workers. It also prevented the exploitation of minors who would either be forced into employment by their families in order to make money and potentially kept out of school. So there was a challenge to the Fair Labor Standards Act of 1938. This was done by the Darby Lumber Company in 1941. The Darby Lumber Company operated only in Georgia. It cut down trees in Georgia and employed people in Georgia. When it sold lumber, it sold it to companies that operated in Georgia. And the Darby Lumber Company argued that the Fair Labor Standards Act violated its 10th Amendment, which stated that the federal government may not regulate its commerce within the state. And the 10th Amendment states that whatever powers that the federal government does not have, that the states are allowed to regulate and formulate laws that the federal government cannot institute. Therefore, the state of Georgia should be regulating the commerce for Darby Lumber Company and not the federal government. The Darby Lumber Company also argued that the Fair Labor Standards Act violated the company's Fifth Amendment rights. This was because the Fifth Amendment states that one cannot self-incriminate, and by keeping records pursuant to the Fair Standards Labor Act of 1938 and showing violations, the Darby Lumber Company argued that this would be a form of self-incrimination by keeping these records. Originally, an appellate court sided with the Darby Lumber Company. So this case went to the United States Supreme Court, and the Supreme Court ended up overturning the appellate decision. It determined that the Fair Standards Labor Act of 1938 was constitutional under the Commerce Clause. This was because it said that the federal government may regulate labor standards by preventing states from utilizing substandard labor practices to gain an economic advantage. So that lumber company did not directly engage in interstate commerce, but because it affects commerce with other states by giving it an unfair advantage that other states may not be able to employ, therefore it would affect interstate commerce, and therefore Congress may regulate that interstate commerce via the Fair Labor Standards Act of 1938. It also deemed that record keeping was appropriate. This was due to other past court decisions that set a precedent. Next, I'm going to talk about the Civil Rights Act of 1964. The Civil Rights Act of 1964 outlaws discrimination based on race, color, religion, sex, and national origin. This allows people to be treated fairly in the workplace and consumers to be treated fairly as well. Everyone should be treated equally. So the Commerce Clause was utilized to uphold the act. And the goal of this was to prevent the discrimination of African American customers. So there was a challenge to the Civil Rights Act of 1964. This was by a case conducted by Heart of Atlanta Motel Incorporated versus the United States. Again, this took place in Georgia, and it was a motel that refused to rent rooms to African American patrons. The Heart of Atlanta Motel argued that the Civil Rights Act violated its Fifth Amendment. The portion of the Fifth Amendment that was violated per the Heart of Atlanta Motel was that the Civil Rights Act resulted in deprivation of property without due process. Essentially, the federal government is taking over a portion of the motel, is what they claim, and that they have to serve these individuals. It also argued that the Civil Rights Act violated the motel's 13th Amendment right. The 13th Amendment establishes that involuntary servitude is illegal, and when this Civil Rights Act forces the motel to rent rooms to patrons that it otherwise would choose not to, the motel is arguing that this is a form of involuntary servitude. Now, luckily, this court decision didn't have to go all the way to the Supreme Court. The District Court for the Northern District of Georgia ruled in favor of the United States, and this allowed the Civil Rights Act to continue and leave a fair playing field for all individuals in the context of engaging as a patron in an establishment. So what they argued was that accommodations for African Americans fell under interstate commerce. The Fifth Amendment does not forbid regulation of interstate commerce. So essentially, the Interstate Commerce Act supersedes the Fifth Amendment in the Bill of Rights. And essentially, when you're regulating interstate commerce per the district court, it's stated that this regulation does not constitute the taking of property, and therefore due process is not necessary. It also stated the 13th Amendment primarily refers to slavery, and that providing accommodations is not involuntary servitude because the motel is being compensated for its actions, and no one is forcing the motel to engage in commercial activity as a motel. In addition, the motel has patrons from outside the state that come to the motel, and the motel is also located adjacent to interstate highways, allowing the argument that the motel is engaging in interstate commerce. Therefore, the Commerce Clause may be in effect, allowing Congress to uphold the Civil Rights Act of 1964, therefore superseding any state laws of Georgia, allowing the federal government to establish a level playing field for patrons who are normally discriminated against. Finally, I'd like to talk about the Patient Protection and Affordable Care Act. This is also known as Obamacare. It was designed to increase health insurance affordability and improve quality. It introduced health insurance exchanges, which the goal was to increase competition between health insurers and allow more plans to be available to individuals. It prevented denial of coverage based on pre-existing conditions, and it also required a minimum level of health insurance coverage. The way it did this was by a section called the Individual Shared Responsibility Provision, also known as the Individual Mandate. Now, the Individual Shared Responsibility Provision required a minimum level of health insurance for individuals and families to be purchased. There's a penalty if individuals or families were non-compliant, and the penalty was done so via a fine, and if the fine was not paid, tax returns would be reduced in order to pay for the fine. The authority was originally rooted in the Commerce Clause. the Commerce Clause tried to argue that a non-purchase of insurance was commerce. This was done by stating that individuals, by the nature of their existence, are in a healthcare market. If you're walking down the street and you have a heart attack, you will be helped likely by an ambulance and by a hospital. Therefore, your state of being, it precludes you to being in the healthcare market, and therefore it may be regulated under the Commerce Clause, and more specifically via interstate commerce. This would give Congress the power to continue with the individual mandate. So, of course, there was a challenge to the individual shared responsibility provision. The 11th Circuit Court of Appeals ruled the provision was unconstitutional. It stated that failure to purchase coverage is inactivity, and if you are inactive, you cannot engage in commerce. Therefore, if you are not engaging in commerce, the Commerce Clause and the Interstate Commerce Clause cannot regulate individuals in this fashion. So this case went all the way to the Supreme Court, and the case was the National Federation of Independent Businesses versus Sibelius. The Supreme Court ruled that the Commerce Clause cannot uphold the individual mandate, and therefore Congress would not have the authority to require the purchase of health care. It stated that one may want to pay for health insurance out of pocket, and then therefore its inactivity does not preclude one from engaging in the healthcare market. You're still in the market, but you can't force someone to purchase this health insurance via the Commerce Clause. And this is important because the ethical dilemma resulting from this act is that the federal government was essentially attempting to force individuals to do what's best for them. It's best to have health insurance so you don't go bankrupt, so you don't cause an undue burden to society's healthcare system. Hospitals will have to pick up the cost, or other local governments. However, one must weigh the benefits to society with the coercion that a federal government may have on an individual simply by being or their inaction. And one has to weigh these options, whether it's best to have an authority force you to do something that's best for you, or let individuals make their own choices, even at the detriment of themselves and society. Eventually, the individual mandate was upheld by the Supreme Court, but not through the Commerce Clause. It was upheld by the congressional power to tax individuals. So one is not being forced to purchase health insurance, merely they're being taxed at a higher rate if they do not have a minimum level of coverage. So in conclusion, the Commerce Clause enforced, or attempted to enforce, ethical standards in the United States. It did so under the guise of regulating interstate commerce. The Fair Labor Standards Act of 1938 attempted to set a minimum playing field for individuals and workers so they could have a better standard of living and mitigate the exploitation of minors, and the Commerce Clause upheld that act. The Civil Rights Act of 1964 allowed for individuals to be treated fairly, so they would not discriminate against based on their race, sex, or national origin. And again, it was upheld via the Commerce Clause by stating that businesses engaging in interstate commerce must treat individuals fairly via the Civil Rights Act. And the Commerce Clause attempted to uphold the Protection and Affordable Care Act segment that included the individual shared responsibility provision. However, this was struck down, and this was a source of vast debate whether an authoritative body doing something that's good for you is better than an individual choosing a choice which may be harmful to themselves and others. And ultimately, it was not upheld by the Commerce Clause, although it was upheld by congressional tax law. And so that concludes my presentation. Thank you for listening, and I hope you learned something today.